Thank you.
Good afternoon, sir.
Good afternoon.
कोई बात नहीं, अब ये बात तो नहीं है कि भाई कंपनी का बैंक का प्रोसेस, अब कहीं भी कोई बात होती है तो उसमें बोलना पड़ेगा कि मुझे प्रोसेस का अब लोन की पेमेंट भी जानी चाहिए, लेकिन बाद में भी जा सकती है तो मैंने हाँ तो ठीक है। अब बैलेंस पेमेंट को देखो, ये किसकी करिए और उसकी देखो कि
Good afternoon, sir.
Good afternoon, everyone. Danisa ma'am.
Yes, sir.
I think we should start now.
Okay, sir.
Okay.
Sir, I am audible.
Yes, ma'am, you are.
Ladies and gentlemen, a very good afternoon to each and every one of you present here. I am Danishta Khan, Assistant Professor, Faculty of Education at Mahavir University. And I am delighted to be your host for this 10 days national interactive workshop on quality writing skills for social science research and research methodology. It's a great honor to welcome you all to this event, which is organized by Mahavir University. This workshop offers opportunities for fair and free discussion on a given topic. Participants express their views in a systematic and analytical way so that each aspect of the topic is thoroughly discussed in the modern world characterized by fast educational growth. As you all know, today's workshop is the first day of our 10 days national interactive workshop. So enjoy and stay in the workshop till the end. Before starting the program, I would like to tell you something about Saraswati Vandana. The Saraswati Vandana mantra is one of many mantras chanted to gain favor with the Hindu goddess. Saraswati, known as the mother of the Vedas and champion of knowledge, wisdom, and the arts, Saraswati is also considered a part of the trinity of Saraswati, Lakshmi, and Parvati. Now I would like to call respected Professor Dr. S.P. Singh sir, Professor and Dean Faculty of Education at Mahavir University to play the video of Saraswati Vandana.
Ma'am, wait a minute, please. मैम शेयरिंग पॉइंट शायद मैंने क्लोज कर दिया है, जो अभी ऑन नहीं हो रहा है, और इसको थोड़ा समय लगेगा इसको ऑन करने में. आई थिंक वी शुड गो अहेड.
Okay, sir, no problem. Now starting, I would like you to introduce our Mahavir University. Mahavir University is located on Sardana Road, Meerut, Uttar Pradesh. The lush green campus, with its uniquely designed architecture, stands out as an infrastructure. The university offering various multidisciplinary programs in varied streams of Ayurveda, pharmacy, sciences, management, commerce, law, arts, education, agriculture, computer application, and library sciences. The Mahavir University Prime focuses on holistic learning and competitive abilities in students. Mahavir University is also having 100-bedded hospital and Ayurvedic Medical College and hospital MAMCH. Now, today, there is such a power amongst us that if we talk about her honor, respect, and prestige, then words would fall short. She has nearly 20 years of experience in the field of education. She has published education related research articles and papers in various national and international peer-reviewed and UGC-approved journals. Under her guidance, as principal in Satyug Darshan Institute of Education and Research, which is Women's B.Ed College, has made an unprecedented constitution to all-round development of the prestigious teachers. Along with this, Jugnu ma'am is also working as Secretary Finance in CTPD, which is Council for Teachers Professional Development. The CTPD Research Circle is a group of senior academicians and scholars. The research circle organizes research related programs in collaboration with other professional bodies. Now I would like to call respected Dr. Jugnu Khattar Bhatia ma'am for welcome speech.
Thank you so much, Danishta Khanji. Hope I am audible to everyone.
Yes, ma'am.
Yes, ma'am.
Thank you so much. Respected dignitaries, esteemed guests, faculty members from various organizations, and our dear participants. A very good afternoon to all of you. And it gives me an immense pleasure to welcome you all to the National Interactive Workshop on the theme Quality Writing Skills for Social Science Research and Research Methodology. It is being organized by Faculty of Education, Mahavir University, Meerut.
Any type of volular regurgitation, though the common type of volular regurgitations are, it is most of the time it is the
May I request to please mute yourself?
regurgitation. फिर और भी हो सकता है, राइट हार्ट की बात करते हैं, इट कैन बी बिकॉज ऑफ ट्राइकस्पिड रिगर्जिटेशन, जो एओर्टा से राइट एओर्टा से राइट वेंट्रिकल में होता है, ये पल्मोनरी वॉल रिगर्जिटेशन जो वेंट्रिकल से लंग्स को सप्लाई. तो किसी भी तरह के रिगर्जिटेशन के अंदर क्या होता है रिगर्जिटेशन में होगा, समझाओ तुम, बैठे बैठे बोलो. हाँ, कब होता है, तो कब?
Hello, am I audible now?
Yes, ma'am.
Thank you so much. So basically this workshop is being organized by Faculty of Education, Mahavir University, Meerut, in collaboration with CTPD India. And this particular workshop marks a significant step towards advancing the research capabilities and writing skills, which are very essential for impactful contribution in social science. I am Dr. Jugnu Khattar Bhatia as a founder trustee and the Secretary Finance of CTPD. Proud to share a brief introduction about our organization. The Council for Teachers Professional Development, that is CTPD India. We are registered on NGO Darpan under Niti Aayog and dedicated to empowering higher education teachers across the nation. At CTPD India, our focus is on organizing conferences, seminars, and workshops to facilitate collaboration and professional growth among educators. We are conducting training and faculty development programs to equip teachers with modern methodologies and tools. We are also in the publishing valuable educational resources, fostering research, partnerships, and supportive innovations in education. And our initiative align with key national and global goals, which includes the National Education Policy 2020, Sustainable Development Goals, and the Viksit Bharat 2047. By fostering a vibrant network of educators, we aim to strengthen the teaching profession and elevate the standards of higher education in India. This particular workshop exemplifies our mission. It will provide a platform to delve into essential aspects of research methodology and writing skills, ensuring that social science research continues to make meaningful contribution to academia and society. I extend my heartfelt thanks to Mahavir University for partnering with CTPD India in this noble endeavor. To the participants, I urge you to actively engage, exchange ideas, and make the most of this interactive learning opportunity. So let us work together to enhance the quality and impact of our research, paving the way for a brighter and more informed future. With great enthusiasm, I once again congratulate Dr. Shivpal Singh and Faculty of Education, Mahavir University, Meerut, and wish you all a productive and enlightening experience throughout this workshop. Thank you so much. Over to you, Danishta Khan.
Thank you so much, ma'am, for your valuable words. Now I would like to tell you about the topic of the today's workshop. Today's workshop, a very most important topic, intellectual property rights, proper attribution, copyright issues, and intellectual property right, aims to bring to light various aspects associated with this topic, thereby sparking thoughtful discussion and stimulating new ideas and open discussion. Research opens up new realms of thought, new domains of knowledge, and new theories and principles. It also solves problems. It also has the ability to assess and challenge current theories in the light of the current situation. Therefore, it is educational professionals understand research methodology or the process of conducting research. It is important to note the research is a methodological process and understanding research technique can assist one to decide. Thus, it is this circular for a researcher to be aware of every percent and stage of the research process in order to make it more methodological and consequently to put an end to concerns about the validity and reliability of his or her work. The train in research methodology will become her the different facts, instruments, and procedures involved in carrying out social science research. Through this workshop, the participant will be introduced to a variety of research methodologies, mixed methodologies, and qualitative and quantitative approaches. Qualitative methods such as understanding data, survey methods, and sampling. Question queries, design, hypothesis, test, academic writing, and publishing, avoiding plagiarism, artificial intelligence, etc. Now, I would like to call Professor Dr. S.P. Singh sir, Professor and Dean, Faculty of Education at Mahavir University for about workshop.
थैंक यू मैम। मेरी आवाज आ रही है आपको?
Yes, sir.
थैंक यू। गुड आफ्टरनून one and all present on virtual platform.
Good afternoon.
This is Dr. Shivpal Singh, Professor and Dean, Faculty of Education, Mahavir University, Meerut. Welcome to our today's resource person, guests, educators, faculty members, research scholars, and students. In our first day of 10 days online national interactive workshop on topic quality writing skills for social science research and research methodology. Let's open our minds and heart to new ideas as we come together to learn new facts and share knowledge. It's my privilege to welcome our today's eminent guest speaker, Dr. Nizam Khan, Associate Professor and Head of IPR Cell, GD Goenka University, Gurugram, Haryana. Today, he will discuss in his lecture intellectual property rights, proper attributes, copyright issues, and intellectual property rights. He has generously agreed to share his expertise with us. He has also a vast experience in research methodology. So welcome you, sir. This National Interaction Workshop is collaborated with the CTPD, Council for Teachers Professional Development India. So we welcome the team of CTPD India for collaboration with us. The CDPC Research Circle is a group of senior academicians and scholars who met regularly, share their experience, provides feedback on issues related to research, and provide a research-related support. The Research Circle creates a research environment by creating a supportive community. Anyone who has an interest in research can join CDPT and its research circle. The research circle organizes research-related programs from time to time in collaboration with other professional bodies working in areas of research. So welcome the team of CDPD. Here is new word of interactive workshop. As you have seen in our brochure, a 10-day national interactive workshop. You have heard a lot of places. There are workshop, state level workshop, national level workshop, international level workshop. But today you are seeing, you are watching, you are among us in interactive workshop. So what is an interactive workshop? I would like to say a little brief introduction about the interactive workshop. Interactive workshops are a great way to encourage creative thinking and brainstorming. For example, when your goal is to generate ideas, solve problems, or decide on a strategy as a group. As a general rules, these workshops are run to a person over a minimum of 2 or 3 hours with the help of a facilitator. Interactive workshop activities can help by offering the following benefits: maintain focus. Workshop activities require all of your participants' attention because they cannot sit back and watch. They need to chime in, but beyond keeping everybody involved, these exercises also keep your meeting in a track. As a general rule, these workshops are done in a person over a minimum of 2 or 3 hours with the help of the facilitators. However, online interactive workshops are becoming increasingly more popular as they allow a global team to collaborate regardless of their physical location. An interactive workshop is distinct from a stands meeting because it aims to the stimulate creatively through the collaboration working. A meeting in constraint usually the involve planning and reporting work with the attendees sharing their individual points. It does not involve group activity live in the meeting also. Meeting may be an hour or less. Where is the minimum time need for the interactive workshop is 2 or 3 hours. We also do not include training a workshop, talk, or a seminar in our identification because from our experience they tend to comprise lecture and tutorial, not brainstorming activities. However, it could be possible to have an interactive workshop session as part of the longer workshop. There are many rules, but I would like to 1 or 2 rules to share here. Like, decide whether an interactive workshop is the right choice. Interactive workshop can be useful in many situations with both internal or external participants. For example, case study. Interactive workshop may be suitable for like gathering ideas of a research grant proposal, ascertaining user requirement of the bio-interactive services, generating ideas for designing web or a software interface, solving program such as a possible improvement or a work strategies, deciding properties, strategies and vision, improving working relationship through team building such as part of a retreat. Before you start planning, it is important to determine whether an interactive workshop is an right choice. For instance, they are usually visible at the inception of a project when you need the identify of the goal, organizational leadership policy, and many other factors may determine this. However, once objectives have been identified and agreed upon, then an interactive workshop can be valuable to explore how to meet them. Interactive workshops are also unsuitable when you have firm alternative to evaluate, like mock-up for a website. It would be better to get individual feedback than collect result. Another considering is that the interactive workshop can require extra time and resources to plan and deliver because the activity, template and material need to be prepared in advance and more people may be required for the facilitating activity. We suggest if there are a significant constraint, especially short time scale, it may be more appropriate to hold a standard format meeting. So there are lot of rules of the interactive workshop, but today we come here for the today's topic. So we will learn about today intellectual property rights, property attributes, copyright issues, and intellectual property rights. We have to learn a lot. All of these questions answered we can get by the healthy discussion in the session. So come together, let us all take advantage of this opportunity to grow, learn together. Once again, I would like to welcome our resource person, guests, faculty members, research scholars, and other all our audience to join with us. Thank you very much. Over to Danishta ma'am.
Thank you so much, sir, for your valuable words. Now, I would like to call Mr. Abhishek Sarma, sir, Assistant Professor, Faculty of Education at Mahavir University, for our guest speaker's introduction.
Thank you, ma'am. Am I audible? Okay.
Yes, sir.
So this is Abhishek Sharma. I'm assistant professor at Faculty of Education in Mahavir University, and it's an absolute pleasure to introduce someone who truly needs no introduction in the world of education field. Our esteemed resource persons for today's workshop, Dr. Mohammad Islam Ashraf Khan, sir. With a remarkable career spanning over 12 years of experience in teaching, research, and administration in the field of teacher education, with up-to-date knowledge of government policies, guidance, management, and wide range of teacher development programs. Presently, Dr. Mohammad Nizam Ashraf Khan is working as a post of Associate Professor of Law and Head of IPR Cell in GD Goenka University, Gurugram, Haryana. Dr. Mohammad Nizam Ashraf Khan has made a significant impact as an Associate Professor of Law and Head of IPR Cell in GD Goenka University, where he has been at the forefront of DNLB honors from Lucknow University and post-graduation LLM with business law as areas of specialization from Hidayatullah National Law University, HNLU, Raipur. Dr. Khan has done doctorate PhD on taxation law from School of Law, Galgotias University, Greater Noida. Dr. Khan has a rich experience of more than 12 years in teaching and academic administration, during which he has also associated with School of Law, Galgotias University, Greater Noida, and Institute of Law, Nirma University, Ahmedabad. Dr. Khan has keen interest in legal and interdisciplinary research and has 25 plus publications in its credit. Dr. Khan has received the scholarships and grants in the past, including GAJE, Indonesia, RU, CIPRS, CUSAT. Dr. Khan has delivered lectures in various faculty development programs on IPR research methodology and research publication and ethics, organized by E and ICT Academy, IIT Guwahati. Dr. Khan's areas of interest are IPR, taxation law, and corporate laws. So we are incredibly fortunate to have him here today to guide us through what promises to be a transformative learning experiences. Today we have the golden opportunity to learn from him as he takes us on a journey through intellectual property rights, proper attribution copyrights, issues, and intellectual property rights. So without further ado, let's give a warm round of applause to our extraordinary guest, Dr. Nizam Khan, sir. You're welcome, sir. Thank you. Over to you, Danishta, ma'am.
Thank you so much, sir, for your kind information. We are fortunate to have with us today some speakers who are noted figures in education field. Each one of them brings their expertise and beliefs that will indeed make our exploration of the workshop topic a fruitful and enriching experience. Now, without further delay, let's begin our journey into the knowledgeable world of research methodology. I am honored to invite Dr. Nizam Khan, sir, Associate Professor and Head of IPR Cell, GD Goenka University, Gurugram, Haryana, our speaker of the day, to come and share his valuable views on the topic. We hope that the workshop will offer all necessity and inspire us with great perspectives. Please welcome, sir.
Thank you. Thank you so much, Danishta ma'am. Thank you to SP Singh sir, and thank you to Abhishek Sharma sir also for giving me introduction. So it is nice to witness this August gathering. As I can see, there are more than 200 participants are there. So I think it is a huge crowd, be it online, but the crowd is or the participants are like having lot of expectations. Maybe because of that, they have eagerly joined this prestigious interactive workshop. As SP Singh sir has already said that there are various types of workshop is being held earlier, but this is a unique kind of workshop where we will try to have as much as interaction, so it should not be monotonous and you should also not feel disconnected. We'll try to have this interaction as much as we can. So not wasting much time, just let me share my screen so that you can see my PPT. I think, is it visible?
Yes, sir.
All right, so I'll start this slideshow. So this topic, as I can see, this workshop is basically related or majorly related to that particular point, which is being considered as this research and research methodology. Nowadays, this research has means every time research is important. So this intellectual property, some of you may think that why and how this is related with research or with respect to that particular thing. So whatever research and whatever things in the field of education and teaching we are doing, that is majorly being considered as intellectual property, right? So we have heard about a lot with respect to copyright. So this is like one of the aspects of intellectual property, right? So this subject of intellectual property right is a very vast subject. It is having major sub kinds or subheads that we will be discussing each in not in detail, but we will be focusing with as the topic is related to the copyright issues, because for us academicians, for majorly we are focused with respect to copyright, with respect to plagiarism, with respect to the issues related to copyright piracy and infringement, all these things. So there are other aspects, but we'll be just giving a overview and majorly we'll be focusing and discussing with respect to copyright. As I think, can I have a quick feedback whether means all of you are having some knowledge about intellectual property, right? Or is there, this is the first time you are listening or hearing about this particular topic, intellectual property, or knowing something related to intellectual property rights? Have you heard about this intellectual property? What is intellectual property? What all things comes under intellectual property rights, IPR? Participants? I just want to have this the background, so accordingly I can start or give my lecture. Otherwise, if I'll be giving the lecture and thinking, having that perception that, oh, this thing so you must be knowing, so then you will not be able to understand. So just want to know that what all you know about this particular subject, intellectual property right. Have you heard about this intellectual property rights earlier?
Yes, sir.
Yes, sir, we have heard
Yes, sir.
about it.
So what all
IPR.
you
These are
are getting with respect to
patent
intellectual
right.
property right, that copyright only things are coming, or what is intellectual property right according to your understanding?
Yes, sir.
Ye-
Good afternoon.
Yes, sir. I understand
IPR.
because I'm a law
So it is
graduate,
patent
Oh,
right,
great. Very nice.
patent,
so that I
design,
know
patent,
that the
trademark,
intellectual
You have
trademarks and
you have
copyright and
studied that very
patents,
trade
subject.
secret.
Right, right.
Mm.
All right.
patent
So
and trademark copyright.
good, good,
Sir,
good, good.
sir, I think something which is original and creation of our own mind need to be credited to us. That's why we need to, whenever we write something, we need to have some, I don't know, some sort of legal thing which you are calling intellectual property rights, means out of our intelligence something original if it comes out, then we need to have some legal right over it, and nobody else can publish it without our consent or cite it. I think it is related to this, if I'm right.
Right, right. Very right. So there are two, three things. Basically, one is being considered or referred as intellectual property, and another is referred as intellectual property rights. That is, we are saying IPR. And one is also that is being considered as IP, intellectual property laws. So that is related to legal field. Laws are there. So that will be taking care with respect to any infringement or any violation of the rights. So intellectual, we create intellectual property, and then it is being provided us as a right. That is why it is being called as intellectual property right. So I'll start with this particular basic thing, that what is IP? That is intellectual property, right? First and the foremost question with respect to this, that what is intellectual property? According to you, that the original creativity is considered as intellectual property?
Yes, sir.
Right. So the simple meaning with respect to intellectual property means anything that is the creation of human mind. Right? So creation of human minds, here I would like to stop, because there is a very interesting case with respect to this very point, the case study, that anything which is being created or which is being, like, you can say that this is the originality, this is the creativity, this is the original thing, but not from human minds, because nowadays is of AI, artificial intelligence, robots and robotic things are coming into picture. So there are a lot of debates nowadays, contemporary issues related to in the field of IPR related to artificial intelligence is coming this only. Till now, the settled principle is there that intellectual property means anything that is the creation of the human mind. It means if there is any original thing, if there is any creativity by any other person apart from human minds, that will not be considered intellectual property. That will not at all be the part with respect to intellectual property. So there is a very interesting case with respect to this very point. That is a very famous case. I think many of you have heard about it. That is a monkey selfie case. Right, nowadays is the era of this selfie. We are clicking so many pictures like in that manner, in this manner. That is with respect to the selfie point. So there is a very famous case with respect to this that is being called as monkey selfie case. Does anyone have heard about this very case or any knowledge about this case? Chimpanzee case, you can say, or this monkey selfie case. It is famous by the name of monkey selfie case. Any one of you have heard about this case?
No, sir.
No, not at all. No issue. Will discuss. So basically, this case is on this very point where it will prove that yes, this intellectual property means anything that is the creation of the human mind. So monkey selfie case, what happened in that particular case? There was a one wildlife photographer called David Slater. He was a Britishers, means he is a Britishers, not was, he is a Britishers. And this case is of 2000, between 2010 to 2015 around. So he is a wildlife photographer, British wildlife photographer. He wants to take a very unique picture of monkey, very close picture of monkey, but he was not getting in whole UK, United Kingdom. So he traveled from United Kingdom to Indonesia, this zoo, and he just tried to capture some of the pictures of the monkeys were there in that particular Indonesian zoo. So he tried to capture few pictures, but he was not confident and he was not having that much happiness because he was not able to get that very picture which he was intended to get. Right? Now he was very frustrated. He was sitting at a place and he was having at that very time DSLR camera, like wildlife photographer is having very unique, very costly wildlife, this DSLR cameras. So he was just looking his this images that he has clicked in his DSLR camera. Then he was frustrated and there was a tripod where he has kept his DSLR camera. Then suddenly what happened? One monkey jumped from the tree and snatched his camera, because we know that monkeys are very like curious. They try to know what this and what that, and they usually snatches the thing. So one monkey jumped from the tree and snatched his camera. And who he was in the time he tried to understand what happened, that the monkey got the possession of that very camera. And then monkey was like very curious. The monkey was just checking what is all this device, how this person is doing this like that, and he was just pressing the button, and he has clicked some picture by itself. Now, after certain efforts, by giving certain kind of exchange, banana and all, that monkey has given back that particular camera to Mr. David Slater. Then David was just checking whether his device is, because it was very costly, whether it is, if this device is good, it is not been harmed, damaged or not. Then he jumped suddenly, like called Eureka, Eureka. So he said that, yes, this is the picture that I was looking. He got that picture. I'll just show you that picture. Let me just show you that the picture, so that you will be able to understand. I have this. See, this is the picture. This was the picture which was being clicked by that very monkey. Are you able to see this picture? This is a
Yes,
bit of the monkey called chimpanzee. So he was given a unique name also, Noreto. This monkey's name was Noreto. So the dispute arises after this, right? This was the picture. So now he was very happy. He returned back UK happily with respect to that very point, that I got the picture. For that, I went there. And then what happened? This Wikipedia encyclopedia, they have also published that very picture, because he was wildlife photographer, David. So he has sold that very picture to certain magazines, and he was getting some royalty benefits out in exchange of those pictures. Now what happened, after certain time, this Wikipedia also taken that very picture without their permission. So copyright is saying that unauthorized use of a copyrighted works is being considered as copyright infringement. Right? Means if I am having a copyright on that a particular thing, and you want to use that particular things, then you first have to take permission. So that Wikipedia has not taken any permission, and they have used that picture. And then David objected these things, that how you can take this picture without my permission. Then this particular Wikipedia said that, no, this is not you are not having the copyright on that particular picture. How you can say that I have to take your permission? This is the intellectual property by that particular monkey. Then everybody laugh. How these animals can have this intellectual property? How this animal can have such kind of rights? Then this dispute, sorry. Then dispute arose in the courts in UK, and this lawyer was just talking back of the scene, that now we are not able to decide the rights of the human being. Now we have to decide the rights for these monkeys. This was just the on a loser talk. But in the court, they disputed this very point, that who holds the copyright, whether it is the David Slater will be having the copyright on that particular picture, or that particular monkey. Because if the monkey could have that copyright, then anybody can use without anybody's permissions. Wikipedia has done. But what happened? This case was going on, but out of the court settlement was there between this Wikipedia and David Slater, and there was also PETA also came into picture, that you have harmed that particular animal. Now you have to give certain compensation, like that particular thing. So they made an out of court settlement, and David agreed to share certain profits with this particular PETA also, for this welfare of those monkeys. And to that particular Wikipedia was also agreed. Means they made a this negotiation out of the court settlement. But this case has already been filed in the court. The court and the judge said that, no, we are going to decide, we are going to give a benchmark, we are going to we are going to say a command on this particular dispute, whether this any other being apart from human can have the intellectual property right. Then finally the court decided that no, that only the particular human being can have the copyright. So in that case, what all efforts David has taken with respect to going from UK, traveling from UK to Indonesia, and arranging for all those things, that amounts with respect to the intellectual property right. So that court has decided that the Mr. David is holding the copyright on that particular picture. It is not the monkey, because this any other being apart from human can hold that copyright. So this is the settled principle. After that, debate is going on. Like there are certain kind of software in China there that is creating blogs. AI, artificial intelligence, creating a blog, and that is original blog. So the question is with respect to that, whether that particular AI is having the copyright on that originality or not. Now there are 1-2 cases is also going on in the court in Delhi High Court. One case is between ANI and OpenChat, and one case in Punjab and Haryana High Court, where one student has just taken all the things from Chat GPT AI tools and submitted his PhD, not PhD, LLM dissertation. And this Jindal Global University has rejected that particular thesis and failed him, that you have copied each and everything from this Chat GPT. So he has challenged these things to the Punjab and Haryana High Court, that how this copying from Chat GPT is considered as infringement or like this copyright violations. Right. So these cases are going on, but not going in detail, because this subject is very vast itself. IPR, take it copyright, take it patent, take it trademark, geographical indication, industrial design. There are a lot of things with respect to traditional knowledge. There are a lot of things with respect to intellectual property right. We are not going in detail. So just will giving you the brief idea. So now, till now, the settled principle is that this intellectual property means anything that is the creation of human mind. Right. So what is the creation of human mind? As you can see that all these are the creation of human minds. Right. The particular human minds can do inventions, as we have seen in this Three Idiots, Amir Khan, Bollywood 3 Idiot movies, that he was doing in Ladakh. That was the invention and the creativity. Right. Artistic work, whatever artistic work anybody is doing, that is being considered as the creativity of human mind. Any kind of dramatic work, symbols, films, literature work, so that all will be considered as the creation of human minds. Right. That all will be considered as creation of human mind. So now the question, basic question here comes is that why I need to protect IP? What, like that, you, if you remember, if you have seen that movie that I usually give to my students in the class, Three Idiots, Amir Khan movie, that he was saying that he was just concerned about that particular invention. He don't bother about the money and any other things. So the point is that why you need to protect your intellectual property. Right. So just to answer this question, we can have this particular very famous story, that is of Tom and Jerry IP story. So are you with me? Are you clear till this point that this intellectual property is the creation of human mind?
Yes, sir.
Yes, sir. Yes, sir.
We agreed. So till now is the point. Will see that what law takes its development in the coming years. But till now, as the AI and all these coming into picture also, that till now the settled principle is that only that human creativity can have, that human being can have that much of creativity, and they can hold the intellectual property, be it copyright, be it patent, whatever right is there. So now why should you protect your intellectual property? Any idea? So that nobody can.
So there is no infringement on our rights as authors or creators?
All right, very good. You said encroachment or infringement?
Sir, infringement.
Infringement. Okay, very good. So apart from this, any other things?
Sir, no one goodwill cannot be discounted.
Right. No one should take the as
Goodwill.
for what you can say for granted also. Okay. Anybody else?
We can earn money also.
Yes.
Sir,
Monetary benefit
anybody
is one of
cannot.
the
Yes.
good.
Hello, sir.
Yes.
Anybody cannot use intellectual property by without permission, sir.
Without?
Without permission of author.
Right. So that is why you need to protect your intellectual property, so that if anybody will be using your property, then they just need prior approval from you, right?
Just
That's
like
why you...
land registrations, we should, when we purchase some land or things, we should register it. Just like the same way, when human beings create something with the help of intelligence, then it should be protected. And it is very much important because in the nearby future, anyone can uh, uh, possess this or getting the benefit of others. So it is more important to register the intellectual property.
All right. All right. I got the point. So
So
anybody else
I
would
think
like to...
it is my mental wealth, so I should protect it.
Yes, it is your mental creativity or
Wealth.
this
Yeah, it is
intellectual,
creativity.
that is why you need to protect it. Okay.
Yeah.
All right. So I told you that there is a story. I'll just try to make you understand with respect to this story that you have heard, that Tom and Jerry, very famous cartoon we have watched in our childhood. So now what happened? These two best friends always fighting. What happened once Tom has invented a high-speed supercar which uses water as a fuel. So the Tom has invented a car which uses that particular water as a fuel. Right? Is it possible? Yes, it is possible. Nowadays, Nitin Gadkari ji has also shown some kind of things. The Tom told all process to Jerry that I will be making like this and that in that manner. Then both enjoying the long drive in the same car, right? This Tom and Jerry, what Tom has invented, what Tom has made, they have that Tom has told all the things to Jerry, and both enjoyed long drive. Jerry made the same type of car and got patent, like always, how what Jerry is doing. So the only thing that Tom has not done was not registered. So patent you can consider is the registration thing. So Jerry also made the same, because the Tom has shared all the processes that how he has made it. So Jerry has also copied all those particular things that has been told by Tom and made the same type of car and got patent or got registered. So now the point is that Jerry sold this patent to market or to license to some commercial person and became the millionaire. Jerry bought new homes and enjoying life, and like Tom is always regretting for his biggest mistake. What was the biggest mistake? What Tom has made the biggest mistake?
He didn't register the art creativity.
Right.
Actually.
First of all, he should means Tom should register that particular technology or that particular creativity. Then it should have been shared. It is being said with respect to this intellectual property patent or copyright. Even copyright also, we have seen one more Bollywood movies. You can say that sir is giving so many examples of Bollywood movies, because these movies are the mirrors of the society. They usually see what is been going on in the society. There was one Kapoor and Sons movie, Bollywood movie, and in that particular movie, two brothers were there that is related to the copyright novel. One brother has written that particular manuscript of novel, but he was not getting the climax. So he has just shared that climax with his younger brother or elder brother, I don't remember. And what happened, that elder brother or younger brother to whom he has shared that story, that the climax has come with the same particular kind of story, having that incorporated that very kind of uh, climax, and it got bestseller award. And the brother, he that was not able to put it on a piece of paper, was always regretting like that. So it is being said with respect to this intellectual property, even don't share with your family, even don't share with your parents. First register that particular things, whatever registration process is there, then only you can share with anybody, or with whomsoever you want, right? Like we usually in our desi language, we usually see or say that in our UP or in certain other Bihar places, it is being called as this gamcha फेंक के सीट, रुमाल फेंक के सीट बुक कर देना। जब बहुत ज्यादा पब्लिक ट्रांसपोर्ट में भीड़ होती है, तो हम लोग जो है विंडो से जो है कुछ गमछा रुमाल बैग फेंक देते हैं कि भैया ये सीट हमारी बुक हो गई है, अब जो है हम आते रहेंगे गेट से, भीड़ जब हो जाएगी। राइट, अब वो तो अलग ही बात है कि आजकल के डेट में व्हाट पीपल आर डूइंग, दे आर जस्ट थ्रोइंग दैट एंड विल सिटिंग एंड देन कहिंग ओके आई हैव सेट ऑन दैट प्लेस, यू कैन गो एंड सिट एनी अदर प्लेस। बट द पॉइंट इज टू से हियर इज दैट फर्स्ट रजिस्टर, first of all, give that very priority to the process of the registration, then you can go any other place, be it with respect to that novel, so be it with respect to that any intellectual property, technology, whatsoever, all that we have done. So the same thing that Tom has done, the mistake that he was regretting, that why he has shared that story before registering. So the moral of the story is that you register your intellectual property as soon as possible, as early as possible. Put throw the particular this certain cloth to book that seat, like that. Don't tell even to your friends or to family what invention you have got before get protected, right? I have seen so many like the cases where my students, as I am heading this IPR cell, so in IPR cell we are providing any kind, all kind of IP support. So the student usually come with respect to their ideas, and they say that, sir, we want to protect this idea, how we can protect it. Then I ask the second question that, okay, just tell me what is your idea, whether it can be protected or not. So they are saying, no, sir, I can't tell you, I can't disclose that particular idea, otherwise it will be obvious. You just tell me that it can be protected. I can, then I say that, how can I tell you without knowing that whether you should have at least that very confidence with your particular one person to whom you are sharing that it is, like, means that no one should be disclosing. So in that situations, the point here to say is that even don't disclose whatever idea, whatever title, whatever topic, whatever thing you want to do that, because nowadays is the day of this competition. So everywhere these things are happening. So by this, generally what we are getting, intellectual property means like that IPR. So a way by which one can protect their intellectual property, their mind, their mental creativity, whatever they have created with their minds, they can protect. How they can protect? Through this IPR, right? So this also gives exclusive right to the owner or the creator of that intellectual property for certain period of, there is a limit with respect to time period, right? Different time limit is there. I'll tell you that what all time limits are there. So with respect to this particular exclusive right means, जो गाना था किसका था वो, I think गोविंदा का था, मैं चाहे जो करूं मेरी मर्जी. So that means that this intellectual property rights gives the exclusive rights to that particular owner or the creator, right? Whatever, whether they want to keep it, whether they want to give on rent, they want to make more copies, they want to license it, whatsoever is that, remake, whatever is there, they can do that. And what it does, it prevents others from that, what you have said, that making, selling, distributing an invention without the permission of the owner, without their permission. So these
Sir,
are
excuse me.
different intellectual property right. Any
May
doubt
I
or
interrupt you, sir?
question?
Just a minute.
Yeah.
Sir.
Yes.
Just I want to know that you said that that student did not share that idea, very much
Yes.
idea to you. when you are discussing, then shall we take affidavit or something legal thing
Yeah.
that you will not share? If you
Right,
share,
right,
then
right.
you will be responsible for that.
Yeah, yeah. Thank you so
Can
much
we
for
can we
this
go?
question. I
Can we go for
wanted,
it?
yeah, yeah, I got it. I wanted to just discuss this thing, but I thought
Okay.
that it will be like in detail, so I will not be able to cover the topic what I mean to
Okay, okay. No
cover
worries.
it that,
That's
because
my
that is the part of, no issue, no
yes.
issue. I'll discuss that is the part of that patent. So there is
Yes.
a thing called as
Thank you.
IDF, Invention Disclosure Form. It is a kind of legal document that you can say that is required to be disclosed between the inventor and that particular the person, because this is the idea usually is with respect to a patent, and patent is the most crucial things like the all these technology, computer, laptop, whatever TV the technologies are coming, satellite, all these are coming with respect to that particular technology things. Now there is a process for the filing that you means we the common people cannot file that particular patent because it is requiring the technical advancement. So the technical person is there that is being called as patent agent, right? They need to file that particular patent application in the patent office. So there is a IDF, Invention Disclosure Form, that is required to be filed by that particular inventor, where the inventor will be disclosing their invention, and that will be the confidential agreement between that particular patent agent and the inventor. It should not be like that the particular inventor, be it a student, be it any faculty, be it any person who has shared with that particular patent agent, and patent agent is saying that it is happening nowadays in the universities also, because NAC, for this NAC accreditation, universities also required to increase this their intellectual property, R&D, and this patenting, all these things. So what they do, they give this facility with respect to that particular this patent agent, and they that the great ideas are there in the university. There is a one statement I usually say, that universities are the graveyard of the ideas. It doesn't mean there are all the great ideas in the universities or in the educational premises, but they are all dying because the people are not giving that much importance, or they are not getting that much exposure. So what is happening, that students, or they give that particular idea to the particular patent agent, and they are saying that, oh, this idea cannot be patented. But what they can do, because this is the technical things they know, and we are the common people, we don't know whether it can be or not. So this is the practical challenge is happening at some places. So what they do, they just sold that idea to third person and say that this idea I am having, you can have that, and to the companies or to the relevant teams also. So that is why these are the challenges that you can say with respect to this procedural aspects. So, but this is there that they need to have a confidential agreement between that inventor and that particular patent agent. So we have in accordingly, and we are not having any such kind of incidents that usually now that students are getting confident and they are sharing, and their ideas are getting patented and protected and published and granted later on stages. Is it clear, Musin sir? Hope I have answered to your question, Musin sir. Am I audible to all?
Yes, sir.
Yes, sir.
Yes, sir.
Yes,
Yes, sir. You are audible, sir.
Yes, sir.
All right,
Sir,
all
I
right.
would like to share an
Yes, sir.
example that comes to mind if you don't mind.
Thank you.
Yeah, ma'am, please share it.
Sir, just I mean, recently it was I think 2 weeks back. There was this issue about domain name of Geo Hotstar that came into a lot of focus because some kid, one brother sister sibling, they had already registered that name with themselves, Dubai based I think. So and then Geo had to buy it for a lot of money. So sometimes ideas and IP are a good monetary benefit thing also.
Yes, perfect. Very, very truly. Nowadays what is happening, like this big giant big companies, they are like trying to take over all those the ideas. If you have any ideas, like usually what is happening, Oyo rooms or other such kind of things was happening, they have like this particular Shark Tank, the particular investors are there, you go with the ideas, they like your ideas and they snatch it. Like you see the particular Reliance has in the marketing this this speedy delivery like of Blinkit. Now they are thinking with this particular idea. This idea is good. So the big giant company Reliance, Tata, they are like the small milk basket and OTP, such kind of delivery systems are there. So they are just taking over, purchasing whole company like that. So they can do so like that. The Hotstar, Netflix, and other like this OTT platforms, people are also making so that they could have the monopoly with respect to that. This is possible. This can be done. Right? So should I move forward?
Yes, sir.
Yes, sir, definitely. Yes.
All
Yes,
right.
sir, please.
All right. All right. So if you have any other questions, so we can at the end of the session, we can have the question answer session. There also, you can ask your questions. If you have any question or in between also, you can ask as your wish. I don't have any problem. I enjoyed to answering the queries because there are so many things in IPR, so that cannot be told by me. So that is usually explored when the such type of like you are asking the questions, then we are able to touch those areas. All right, so these are the different intellectual property rights. So majorly, we know this copyright, patent, trademark, trade secret, industrial design, geographical indications, traditional knowledge, farmers protection right, plant property, plant varieties, biotechnology, semiconductor layouts. There are so many, but majorly we are knowing this. So that is why it has been addressed as others. So now with respect to this intellectual property, one is this earlier, it was, if we talk about the history, then it was industrial property. And the industrial property was having the patent, trademark, industrial design, geographical indication. And the copyright was having a different area. So, but this is also the part of intellectual property nowadays. If you will see that the previous document there, you can see the industrial property. Earlier, the intellectual property was being addressed as the industrial property, and copyright was a totally different aspects. But now it has been like one unit called as intellectual property, which includes patent, trademark, copyright, industrial design, geographical indication, and rest. So what legal rights all these are having, what for what and how they can have. So first is in patent, it is being given for the new invention. There should be some technology involved that then and then only can be the subject of invention. And how it can be done? By filing the application that I told you that there is a techno-legal document called that document specification document is required to be filed, and then only that particular things can be done. So application and examination, there is a fees, government fees is there. So we need to file that, pay the government fees, then only it can be granted, your patent can be granted. And it takes times around 2 to minimum 1 to 2 years times they take from the date of filing till the grant of patent. So here also this in our IPR cell, we are providing this assistance. And the second one is the copyright. It is been also given for the original creative or artistic forms. So there are various things with respect to copyright, all the literary work, all the musical work, all the dramatical work, all these musical songs, sound recording, all are coming under the copyright. The movies, the songs, the drama, theater, whatever we are, even this music, artistic work includes all these drawings, this paintings, this engravings, this what I told you that the photographs that I told you that with respect to selfie, whatever selfie you are clicking, that is the subject of copyright. That is why sometimes we see in our social media platform, whenever we post any picture or any place, then we just write this PC, that is the photo courtesy, right? It is just a kind of acknowledgement that this, although this is my picture I am posting, but it is not means that I am giving a due acknowledgement that this picture is being clicked by so and so. Photo courtesy means that the picture original creator of the picture was that very person, right? In that situations. And it exists automatically, means it does not require to register, but there are two types of things. It can be registered also, in that situations, as soon as you express that particular copyright, that is being considered as subject of intellectual property. So there is a thing which is being called as copyright is not the protection of idea. Copyright is the expression of ideas, right? If suppose I am coming, like I gave you the example of that Kapoor Sons movies, if I am sharing certain ideas with you, that I have this idea, I want to write a book on so and so topic, I want to make a movie, I want to do such and such song, like that, I'm sharing it, but not have materialized it. So this will, and later on you are materializing that particular thing, same dicto whatever I have shared with you, and then I cannot challenge you. Then I cannot take any action because I am not, I can say that, Array, this was my idea, he or she has stolen my idea, but what is the proof that was your idea? You have shared it orally. Nowadays, is CCTV camera, video recording is there. If such kind of things is there, then that can be protected. Even in this, like the lecture, suppose this is also the subject of copyright. I am delivering a lecture, you are listening, and with respect to that, it will be considered as it is recorded, then it is being considered as it is materialized, right? So it is being materialized with respect to that, and on that very point, it will be subject of copyright infringement if any other person uses without giving the credit of my lectures and also getting certain kind of monetary benefits, commercial benefits. So that is copyright. So copyright subsists with respect to expression of ideas, not mere ideas. If I have made a movie, if I have written a novel, if I have written a certain research paper on after that anybody is copying or doing, then that will be subject of infringement, then will be subject of violation of copyright. Otherwise, if I have not materialized whatever idea I am having, that cannot be at all protected under copyright. That is why it is being said that our copyright subsists, copyright exists with respect to the expression of ideas. Trademark, you know, that is with respect to identification of product or service. Unique mark is there, trademark is there, and that you can already that you can get the registration either by using it or by registration. If you are using it, you are not registering, then also you can get the trademark protection, right? That is been there. That means from our 2-3 generations, we are family business, running a family business, we are using it, so this is our trademark. That can also be done, or you can nowadays can go and can register that particular trademark registration, and then you can start the business. So usually the trademark is for distinctive identification of a particular product, right? Brand logo, brand name, like that. Industrial design, it is for the outer external appearance, for this outer shape, whatever is the, even the jewelry design that are all coming, the ornaments that all are the subject of industrial design, like the mobile, outer shape, laptop, chair, maze, bottle, glass, whatever is that particular design. Nowadays, you can see lot of new designs, shapes are coming. These are all the design ID industrial design. Here I would like to tell you that if any one of you is with respect to patenting thing, because apart from this very apart from this particular publication in our education field, nowadays is also being focused with respect to patent, that how many patent you have published or granted, like that. So there is a difference that you need to understand. One is patent and one is design patent. So usually design patent is a misnomer, such kind of concept is not there as per this particular things, but for educational, but for this academics purpose, we are saying it and saying that it is design patent. Design patent term is not there, that is only industrial design, and that is with respect to outer shape. So if many of us is publishing with respect to design and saying that we have the patent with respect to design patent, that is not. If the university or any educational institute is going for the accreditation, the NAC or this NIRF or this NBA, they are also not considering that design patent under the category of patent. The patent is the only that technical advancement which will be like the published and then granted. That is totally different. So industrial design is for that external appearance, and that is not at all having any relevance with respect to the patent. That is totally different. Then the next one is the trade secret. Trade secret is talking about the valuable informations not known to the public. Like we have seen, I will be discussing that if you are saying that this is our trade secret, will not sharing this. Then if you are taking the reasonable efforts to keep secret, that is being considered as that is your trade secret. There is a very good example of the trade secret, that is Coca-Cola. Coca-Cola soft drink, cold drink. The Coca-Cola soft drink, cold drink people, the company is saying that they have the trade secret with respect to their particular, the making of soft drink. So can you imagine that this multinational company is having more than 100 countries, in more than 100 countries, they are having this product, this cold drink, and they are saying that our recipe is the topmost secret. Only the topmost officials like the MD and CEO and CFOs, they are just knowing that. All the other employees, they are not knowing that. So this is like they are saying that we are taking reasonable efforts to keep secret. Then they can keep that particular thing as their trade secret. This is totally up to them. Now, one by one, with respect to that, I have already, I think, very briefly told you this patent. That patent is an exclusive right to owner of that particular invention for the limited period. What is that limited period? The limited period, the patent protections means that the invention cannot be commercially made, used, distributed. The patent owner may give permission to the licensee. You can sold that particular ownership to the licensee. That is happening in pharmaceutical field, in the medicine fields. After the COVID, you have seen that COVID vaccine was there. So that was being created by some patentee. The person was there, but they have sold these particular the vaccines to the big giant pharma companies. There is a very much things with respect to this pharma industry, because I will not be going in there, because there is a subject in IPR in pharma industry. So these pharma people are very powerful people. Even they can convert all these what Donald Trump is saying, that will be increasing the tariffs and all. There is a very much political pressure with respect to that. They are very powerful. Not going in detail more with respect to that, but you can consider that what is happening, the particular creator can sold the license to the pharma company, whatever medicine, whatever pharmaceutical things they have created, and they can get that royalty or the monthly income or that as per their agreement, and these licensee can use their particular inventions, right? So the patent owner may give permission to the licensee or to any third person for the use with their permission, mutually agreed terms. The protection, the term of protection is 20 years from the date of application. Suppose today that what I told you, that the patent takes minimum 1 or 2 years from the filing to the grant. So it doesn't mean when the grant is being given. Suppose today, if you are filing a patent and you are getting protection for 20 years, so the date will be starting from today only, not after 2 years when you will be getting the grant from that very period. So once that patent expired, that the protection ends, it is going in public domain. So what is happening, you are many of you are listening this in the medicine field also, that this particular medicine is generic medicine. It is not patentable medicine. So it means that anyone from public can use, for any, like the pharma companies can use it and can processes can make that very similar medicine. Nobody is going to challenge. That is happening after the expiry of that particular 20 years. Right? The owner of that original person is not having any exclusive right. So what if they want to have that exclusive right? They should have come with a new technology. So that was happening with respect to Novartis, that a very famous case, Novartis versus Union of India, where India has given a very nice example or very nice message to whole the world that we are not like that snake charmer. We have developed, and this has happened in 2012 and 13 when this one Switzerland company Novartis, they were just admixturing some their earlier products, and they are saying that this is our new technology. So, and they want to get the patented because in 2000 this till from 1990 to 2005 was the era where India was suffering this cancer nowadays also. So that the cancer medicine was very costly. So that Novartis wanted to capture the Indian market with respect to that anti-cancer drug. So there they wanted to get the license or that, because the some Indian pharma company were selling those patent drugs, anti-cancer drugs at a very lower price. So that was a dispute, not going in detail in that, but there was a dispute with Novartis case. And then finally it was decided. So the public would not be having with respect to that very point. And this is the certificate that is being given after the grant of the patent. This is the patent certificate. Here you can see that the date of filing is this 8th April 2004, and the grant is being given in 2007, right? So this is from the date where the protection of 20 years will be counted with respect to the 8th day of April 20 for the period of 20 years. This is the certificate which is being given, and this is the date of grant, right? So now the trademark is coming. Trademark is a distinctive sign. So I think we should not be giving much detail. Otherwise, we won't be able to cover that very point of the copyright and the plagiarism thing. So going in quickly with respect to that, we have already told you. You can see that the symbols in usually we can see with respect to this trademark. These are the symbols. Trademark. One is trademark. Second one is trademark, registered trademark, and the third one is the service mark. So these are the symbols that you can usually see at certain places. If you are having at any point here like pen or notebook or laptop or whatsoever with you right now you are having, you can see there is the company name, and there like certain in circle R or TM or SM can be mentioned. So by that you can consider. SM means service mark. It is being addressed for the services. There are certain kind of, all the things has been defined, bifurcated into goods or the services. So the thing which is like the hospitality, education, music, makeup, all these things, hospitality can be considered as service. So anybody want to start a business, do business in the hospitality, in the coaching, in the education, in the marketing, they have to register their trademark as the service mark, because that is service mark. And then this trademark is there and registered. Well-known trademark is also there that do not require to registered, because this trademark registration is for 10 years. And after 10 years, in number of time, you can renew it for the next 10 years. Generation to generation, you want to renew it, you have to pay a fees and you can renew it. Industrial design that I have already told you, that is with respect to outer shape appealing, like all these industries, watches, jewelry, housewares, electric appliances, vehicles. You can see the examples with respect to industrial design. Here you can see it. GI is also a thing, geographical indication. It has been the uniqueness with respect to its identification, with respect to the location, whether it is soil, whether it is air, whether it is that locality. So that is being given, that the originality place is being given. So these are various kinds of examples. Geographical name, Darjeeling teas like this Solapur, this all things are there. Mysore silk, and then this things example that you can see. Alfonso mango, Darjeeling teas. These are like the GI, geographical uniqueness is there. Trade secret that I told you is a formula that can be protected with respect to that. And trade secret is like the example with respect to that I told you, that Coca-Cola, they are having the trade secret. Nobody is knowing. You know the difference between Pepsi and Coca-Cola is this only, that there is the Pepsi, if you have realized or you can see, that is a more sweetie compared to this. The Pepsi product, like the cold drink Pepsi, is more sweeter with respect to the Coca-Cola, the product of the Coca-Cola company, right? The reason is that they have certain kind of their unique recipe that they are saying that it is our trade secret, we won't share it, right? So these are also like few of the examples of trade secret. Now, coming to the copyright, because it is the important thing with respect to copyright. Copyright is a legal term which is describing the rights given to the creator for the literary and artistic work. Apart from the literary and artistic work that I told you, all the literary work, all the dramatical work, all the musical work, cinematography, sound recording is the subject of copyright. So the area of the copyright is very vast. Be it patent is just talking about the technical advances. Be it trademark, it is with respect to trademark distinctiveness of identification of mark. Be it industrial design, it is just for the outer shape of the design. So, but the copyright is including all the literary things, all the dramatical things, all the artistic things, all the musical things, all the sound recordings, all the cinematography, the movies, Bollywood, Hollywood, Tollywood, whatever is the subject of the copyright only. That is why you can see that the development of the legal or the demand of this legal intellectual property right has been increased in this film industries also, because the film people then they wanted to have the legal advice with respect to their films, their things they are doing. Like you have recently seen what had happened in South India. There was a there is a this actress called as Nayan. So this Dhanush, the son-in-law of Rajnikant, famous actor Rajnikant, the Dhanush has filed a case against the Nayan because Nayan has made a documentary, and in that documentary, for the 5 or 10 seconds, she has used the Dhanush image without their permission. So such kind of copyright issues may come. That is why this demand of that legal expert has increased. So all those copyrights things are coming with respect to kinds of work which is being covered that I told you with even the computer programs. You see that all the computer programs, all the mobile apps which is being developed by you, that is also that can be the softwares are the subject of copyright also. Right, the symbol that you can see that this in circle is the registered copyright, and that we are saying that they are having that particular rights. They can sell it, they can keep it, they can make the number of copies, and they can earn the royalties also. Now, and this is also good thing that the longest protection is being given in the copyright. Lifetime plus 60 years means if I have created one copyrighted work during my whole life, whether it is for next 50 years or whether it is for next 1 or year, whatever is the, during my whole lifetime, I will be holding the copyright. There is no time limit with respect to that during my whole time. After my death, next 60 years means one more generation can get the benefit of whatever copyright that I have created or you will be creating. So it is being said that the term of protection under copyright is lifetime of the author, lifetime of the creator plus 60 years. In India and at international level, it is lifetime plus 50 years. But in India, we have lifetime plus 60 years because it is being considered as 60 years is the average age of one person. Now, this is the crucial point which has become a buzz nowadays with respect to due to advancement of these technologies. This plagiarism copyright things has come into effect. So with respect to plagiarism, what we have said that it is just a means of taking someone else's work without their permissions, right? Without their permissions and just passing them as their own, right? That is with respect to the act of presenting another works or idea as your own. Because when you write an paper, research paper, and you write the name of the author, it is being written your name. And if you have taken something and you have not given that particular reference or the acknowledgement, then it will be considered as that it is your idea, it is your thought. That is why it is being said that will be amounted as plagiarism. So what are all the forms of plagiarism? Right? Verbatim plagiarism is there. Mosaic plagiarism is there, which is very prevalent nowadays. Like host plagiarism is there. Self plagiarism is also being avoided, tried to be avoided. Interweaving various sources together, that is all being considered as plagiarism. Means in general, it will be considered as plagiarism. So it is not which type of plagiarism, just for your understanding. There is a verbatim plagiarism, this mosaic, this paraphrasing things. How to avoid the plagiarism is the thing. If you are writing any things, if you quote the text verbatim, then you can put it in an inverted comma that you have said. Usually we see that whenever any big people, they are giving lecture, they are saying that, okay, I am saying this, quote unquote, and converted comma like this and that. So just is with respect to avoiding that particular things, if you are just saying that very things. Give the due credit. The waste thing is that what is the harm with giving the credit? Give the proper citation, footnote, proper references. There are various type of uniform style of citation and referencing. We have to use it and give the due credit. By that you can avoid the plagiarism. There is no harm, and you can use that like this Turnitin, Authenticate, Urkund. There are so many. This drill boat is software is there with respect to check the plagiarism. And the better thing is that you need to write in your own words. So how you can avoid the plagiarism, because there is a similarity report is also there. So whatever you are reading a particular piece of work, whether it is book, whether it is novel, whether it is blog, whether it is whatsoever is that, you need to read it and you need to understand it, and then you need to write in your language. That is somehow we sometimes we say is the paraphrasing. We don't have to do the paraphrasing. We have to write in our own language, in our own understanding, and then also you need to give the footnote. It is not like that you have just copied. Otherwise, it will be in similarity reports. The 100% will come that same similarity. That from which source you are taking and you are writing in your language, then also it will be considered as that yes, you have given the credit, right? And rules to avoid the plagiarism is that if there is less than 7 words from as it is you are copying, there is no footnote required. Between 7 to 50 words, then you can give the footnotes that we have said. And more than 50 words, nowadays it has increased 7 to, which was the first thing, less than 7 word, now has with respect to 14 words. If there is any word that you are taking of 14 less than 14 words, then no footnote is required. It will not be identified by the softwares also. More than 14 to 50 words, that will require the footnotes, otherwise it will come just the plagiarism things. And 50 words, more than 50 words, then you have to give the footnotes and also italicize it, then font size, keep it in 10 in inverted comma, both side compressed 1.5. If it is 1 inch, then it will be considered as okay, you have taken. So copyright, we have already seen that what is happening in copyright. The point is that here you can have the question, what is the difference between copyright and plagiarism? This is the last point of our presentation. What is the difference between copyright and plagiarism? So basically we have seen copyright is an offense against the person who owns the copyright. But plagiarism is an offense against that very author, because in copyright there are two persons. One person may have both designation, but there are two designation in copyright. One is called as ownership and the other is called as authorship. Owner and author, right? Author is the first person who has created that literary work, who has created that copyrighted work. But owner is that particular person who holds the copyright. It is not the author who is holding the copyright under the copyright thing. It is the owner. And that is why we have seen in these like movies, cinematography film, who is holding the ownership? It is being said that the producer, the film producer will be holding the copyright. That is why we have seen these big actors and actresses, they have started their own production house, because they can have the copyright on that particular things. The producer is holding the copyright. In musical things, the music director is holding, whether the singer, composer, lyricist, all are there, but the copyright is with that particular music director. Right? The literary work, you can write a particular, you can be the author, but suppose your university is saying that we will be holding that the owner of that work, or any institute is there, or any organization is there. So that is different copyright person, the owner and the author. And in some cases, like in your case, you can be, suppose I am writing a research paper and want to publish it, then I can also be the author and I can also be the owner if I have published that book and selling it in that situations. Right? So that particular copyright infringement is the offense against the copyright owner, but plagiarism is the offense against the author. That is the fun difference with respect to that very point. Copyright violation is about the failure to that very copyright violation is that particular violations, that this copyright violation is about the failure to pay the copyright holder for the use of the material. And plagiarism is just not giving the proper acknowledgement about that very source. That is why. And copyright violation can be avoided by just taking the prior permission. And plagiarism, how it can be avoided? Just citing that particular source from where it has been taken. So these are the major difference. Now the simple question, which is FAQs, that you can say that can you commit copyright infringement and plagiarism at the same time? Can one commit the copyright infringement and plagiarism at the same time? So a person can commit copyright violation, that is copyright infringement and plagiarism, with the same action. Yes, that can be. How? When one person uses something without getting the necessary permission and also do not cite. So by one, they can hold these both things. They can have these both violation of both the plagiarism and copyright. Can vice versa, can an action be a copyright violation but not plagiarism? Yes, that can also be done. When a particular person properly cites the source but does not have the legal right to use that resource material, then also it will be considered as not plagiarism but copyright infringement. And then vice versa, the can an action be plagiarism but not a copyright violation? Yes. That happens when a person uses material that is not protected by copyright law but does not properly cite the source of law. Right? So a particular protection there is, like the open licensing is there. Anybody can use it. No copyright protection is there. But with respect to that, they need at least this much things that you should acknowledge, right? Like we are doing. We are writing the paper. We are not having such kind of monetary things that we want to take the benefit with respect to that. But we just want these things that wherever our work is being referred, then due acknowledgement would be given to us. Right? So like that, it can be done also without this. So this is like the plagiarism is not as per the law, means there is no law. If you will be doing plagiarism, then you will be penalized. आपको जेल में डाल दिया जाएगा, आपको इतना फाइन देना पड़ेगा, सजा देना पड़ेगा. This is for academic field. This plagiarism rule till now is being made by this UGC, which is like kind of guidance, not with respect to this like what you can say stringent command is there. So this is the scale has been made with respect to the by the UGC with respect to the plagiarism, that if there is a zero level, that the plagiarism less than 10%, no fine. Between 10 to 40%, then the particular scholar would be asked to resubmit the revised script. And for academician, they need to withdraw that manuscript by that particular things with situation between 10 to 40%. If between 40 to 60% it is coming, then in case of students, their thesis or dissertations, this student will be debarred for a particular year back. It will be, and for academicians that it is in the government organization, they will be asked to withdraw the manuscript and they will be denied to give that particular one annual increment. And more than 60%, then totally not acceptable. It will be rejected in the case of a student, their registration will be cancelled. And with respect to academic and research publications, it is like also same that the candidate will be asked to withdraw the manuscript and will be denied to given the right to the annual increment. Also, they will not be allowed to have any supervisor with respect to that for the 3 years. Right? So this is like the basic, what you can say, the guidelines given by the UGC. So the individual university is free. They can make their rules. They can have more stringent policy compared to this. But this is the baseline. This is the bare minimum things. Means this is the at least requirement from all the universities and educational institute is required. So that's all from my side. If you have any questions, if you have any doubts, then we can have the discussion. And I try to make this particular things as much interactive, but there are so many things. That is why I need to cover it. And I could not have much interactions. And due to this, less time limit also is there. So thank you. So if there is any questions, we would like to take all your questions.
सर हेलो
Yes, yes, sir.
ये कह रहे हैं सर प्लेजरिज्म में यदि 10% से ऊपर आता है तो रिवाइज के लिए स्टूडेंट को कितने चांस मिलते हैं?
एक चांस तो मिलता है ना, बोला गया कि अगर 10% के ऊपर है तो स्टूडेंट को रिवाइज करने को बोला जाएगा। वो परसेंटेज कितना जा रहा है, इफ इट इज मोर देन 40% देन उसको कैंसिल कर दिया जाएगा। उसको बोलेंगे अब अगले साल 1 साल ईयर बैक लग गया। और 40% के बाद से जो है 60% वाला ये सीन है, और उसके 60% के ऊपर तो उसका रजिस्ट्रेशन ही कैंसिल कर दिया जाएगा।
जी
दिस इज यूजीसी गाइडलाइंस 2018 में जो उन्होंने दिया है उसके अकॉर्डिंगली है। दे कैन ऑल्सो इंक्रीज और डिक्रीज इट। अभी तक तो यही चल रहा है। यस, एनी अदर क्वेश्चंस?
Sir, I have a question.
Yeah.
Is there any guidelines for any university? Actually, this is good. This guidelines for the researcher, for the scholar, and actually, the most of the plagiarism checker software are paid software, and as a scholar, we do not have sufficient money for purchase them. So, is the UGC have the any guidelines for the?
UGC Urkund is there. UGC has given free of cost to the university. Anybody, if you are a student, you can have that. UGC has given this particular like the anti-plagiarism software Urkund. You can have with it. You know that the private things and the government things how it is working. So that is having of the government type of quality. But Urkund is there, anti-plagiarism software. You can check your particular work, how much percentage is there. That is free of cost. That is not
Okay. Thank you.
You can go and make your account, university's email ID using, and you can use it. Yes, any other question?
हेलो
Yes.
सर एजुकेशन में पेटेंट का क्या रोल है, जरा बता दीजिए।
Just hold on 1 minute. एक कॉल आ रही बहुत देर से। हेलो। Yeah, sorry for this interruption. Yes. So education में patent because of this particular thing what I told you ना, ये जो accreditation वाले आ गए हैं, NAC, NBA, NIRF, ये research की एक quality होती है, because what is happening with respect to writing the research paper is the one thing you can write the research paper, and this patent is novelty का मतलब न्यू इन्वेंशन। कॉपीराइट की ओरिजिनलिटी क्या है? इट इज, you can say, not below standard, but it is a mediocre originality. With respect to that, writing a paper, compilation, if you want to write a paper, you can, on a particular topic, you can have 10 paper related to that very topic, and you can just pick something of the all from all the 10 papers, and you can come with your paper and can say that I am having the copyright. That is your original work. You can have it. That is with respect to the copyright. But with respect to the patent, it is more stringent, or what you can say, it is more novel or more strict. The idea, whatever you are giving, cannot be known to at all by any person throughout this world. Means whatever you are saying is the first time nobody has thought with respect to that very aspects. And it is also involving with respect to scientific invention, scientific technology, scientific advancement. कुछ science technology है उसमें तभी उसलिए ये कहा गया कि नहीं, पेटेंट भी करना चाहिए लोगों को, बस सिर्फ जो है राइटिंग रिसर्च पेपर इज नॉट सफिशिएंट. सो दैट इज व्हाई दिस हैज मेड मैंडेटरी दैट these particular things should also be there. The people should also think about that particular technology. This is the one aspect I am telling you. The second aspect is with respect to कि इंडिया में जितने भी आज की डेट में पेटेंट हुए हैं, आप देख लो 10, 20, 50,000 जितने भी हुए हैं, all the patents, more than 90% patents are being done by foreigners. Chinese, Japanese and US peoples, they are getting patent in India. जैसे मैं नोवाटिस का केस का एग्जांपल बता रहा था, वो स्विट्जरलैंड की कंपनी थी, इंडिया में आगे पेटेंट लेना चाह रही थी. इंडिया में कोई कुछ था ही नहीं, हार्डली अभी भी आज की डेट में लेस देन 10% लोग होंगे जो इंडिया के होंगे जिन्होंने पेटेंट ग्रांट किया होगा. उसमें से भी कुछ ऐसे ही होंगे कि बाहर कहीं किसी कंट्री में है तो लिया होगा, नाम से नहीं आपको वैसे पता चलेगा, उनकी नेशनैलिटी से देखना पड़ेगा. तो जस्ट टू इंक्रीज दिस थिंग ऑल्सो, that is why the government has come with a new IPR policy. Laws are there. Indian Patent Act is of 1970, Indian Copyright Act is of 1957, Indian Trademark Act is of 1999, Geographical Indication Act is of 2000. Means all the laws are there. And international level, this TRIPS came into picture. There is a international treaty convention which came in 1995, which has given the time limit of 10 years to meet the standards of their country's IP laws. So India was getting 10-year time limit, means from 1995 till 2005. So India has made the amendments and changes as per the international treaty in their laws in 2005. After that also the people were not doing these things. There was a very less awareness. You can see that there are very less people who know what is IPR, how it can be protected, what is the importance, what things can be done. Even in among us also we can see these things. So the government has come with IPR policy apart from the law, where there will be talking about such type of sensitization will be there. NIPAM mission was being NIPAM National Awareness Program on Intellectual Property Right. This was the thing which was being initiated by the government of India, just to sensitize about the people what the patent and what the IPR and all these things, so that the people can increase those things and the creativity. So with all these things, this particular patent has also been increased. And with respect to education field, that you can say, that is with respect to like the social sciences or the humanities, people are facing the challenge with respect to the patent publication or patent grant, because the patent is involving this technology things, technical things. So R is like the law, management, humanities, education. These are all is not having any technical things. So there is a interdisciplinary thing. NEP has come, National Education Policy. They are focusing with respect to interdisciplinary. So we can collaborate with respect to those particular technical person, and then we can come with a particular invention or ideas. That is why this has been made mandatory for that particular education field and for us also. Is it clear?
Okay, thank you.
Thank you, sir. Thank you very much. Sir, ये PPT stop कर दीजिए.
Okay, just hold on, sir. So thank you. Thank you, all of you.
Thank you, sir.
I think some participants want to ask
Thank
some
you, sir.
other questions. They have raised their hand.
Oh, okay. So if you allow, if time permits, they can ask, or
No
they can
problem,
have my
no problem.
mail ID. If they can want to connect me later on, they can also connect. So can we have more questions, sir, or is the time is?
I think we have more questions. Some person
Yeah.
who ask, you can use the chat also.
Yeah, please, can we have the next question?
If you have any other questions, please ask.
Yeah, my email ID, I have, okay, I'll just write in this chat also. In PPT, I will share my PPT also. There, the
Krishnakant ji, please unmute yourself and ask your question. You raised your hand. Yes,
yes, sir.
sir.
Your voice is not coming properly, sir. Sir, your voice is breaking. We are not able to listen you. Sir, if you have like any technical glitch, you can write your question in also chat box. We can take it from there.
Yes, sir. I think you should see the chat box. If there is any question, you can.
Is there any question, sir, in chat box?
I have seen, I think there had some questions.
How to register patent? I think this is by the Krishnakant, sir. How to register patent? This is one. So for the patent registration, what I told you, sir, that there is a particular process involving, there is a document called as techno-legal document, a specification. We need to write all the things in a document, and there is a government form, form 1, form 3, form 6, form 5. These are required to be submitted along with a drafting things that is called a specification, where we will be mentioning what is the invention and what all claim we are asking with respect to that particular invention. Right? We want the manufacturing, we want the process of that very things, we want the crusher of a coffee machine, we want that particular process of mixing of that coffee with the sugar or the milk, like that. So then we are submitting it, and there is a government fees which is required to be paid. 1600 rupees is the filing fees, and then government is taking 18 months for the publication of your particular patent. That is been after 18 months, it will be published, going in public domain. Whosoever is having any whosoever is having any objections, they can object it, otherwise they will proceed for the examination. But there is also a process called as early publication. So after filing, paying 1600 rupees for the publication, for the filing, we can pay 2500 rupees for the early publication, and form 9, along with the form 9, we can request to the government for the early publication. So within a month of the filing of the patent will be published. So the people usually are using published, my patent has been published. So this is the not having that much of the seriousness with respect to the research paper publications. That is very crucial, going through a peer review and lot of reviews. But here, whatever you have filed, the government official, IP India officials, they are just taking and publishing it on in their official journal called as patent journal. Right? Then when you are filing for the examination, there is a 4000 rupees, form 18 is required to file it. And when you will be filing for the examination request, then they will be examining your that particular invention or that particular technology. If they finds it useful, then they proceed for the grant. Otherwise, they can reject it, and they can say that your invention is not a new invention, is not patentable, it is rejected in that situation. Is it clear?
I think a lot of questions answer you have given, sir. And as you have sent the email ID, if any participants have a question, they can send an email ID and sir will reply.
In UGC care listed journal, yeah, it is there. So I'll share you. You just mail, you whatever queries you are having, you just mail me. I'll just give all your reply. Hello. Yes.
Yes. Thank you, sir. Thank you very much.
Yeah, sorry, sir. Yes, thank you so much, sir. It was very nice, and the participants is a very, I think, sincere and nice participants. As I can see, there are a lot of questions due to this time limit. We could not have all those questions. And whatever question you are having, you can note down my email ID. You just drop me a mail, and I'll definitely respond to your queries. Would love to respond to your and listen to your queries. Thank you so much. Thank you,
sir.
sir.
Thank you very much.
Share your mail ID.
Yes,
ईमेल
I
आईडी
have just shared.
शेयर की जा चुकी है चैट बॉक्स पर. एंड ओवर टू दानिश्ता खान मैम.
Thank you so much, sir. Thank you so much, Dr. Nizam Khan, sir, for that insightful presentation. We are truly grateful for sharing your valuable insights. सर ने हर एक टॉपिक को इतनी अच्छी तरीके से मतलब एक्सप्लेन किया है कि हर टॉपिक और उसके सब टॉपिक को विद एग्जांपल लाइक व्हाट इज आईपी, moral of the story, what is IPR, a different IPR, overview of intellectual property, copyright, plagiarism and copyright, how to avoid the plagiarism, rules to avoid plagiarism, different between copyright and plagiarism. Can an action be a copyright violation? UGC rules on plagiarism. Every brief explanation with examples. Thank you so much, sir. Thank you so much. Now, as we draw close to the end of this insightful workshop, we express our sincere gratitude to all the eminent speakers gathered here today, shared their expertise and experiences with us, and thank you, our esteemed listener, for your active participants, making this workshop a vibrant pool of knowledge exchange. It has been an intellectually enriching experience, and we trust you all depart with a better understanding and fresh perspectives on our focus topic today. Thank you for making this workshop truly memorable. Thank you so much, sir. Thanks to all. Now I would like to invite respected Dr. Jyoti Singh ma'am, Assistant Professor, Faculty of Education at Mahavir University, for vote of thanks.
Thank you, ma'am. Jai Hind, Namaskar, good afternoon to all. First of all, I, Dr. Jyoti Singh, Assistant Professor in Faculty of Education at Mahavir University, Meerut. Today, we completed our first day of workshop on this beautiful and glorious day. Finally, I would like to convey my gratitude to everyone here for taking the time to join us today and assisting us in making this event a huge success. Thank you to everyone. I'm very much thankful for your energetic, positive session. This workshop really means a lot to us and has encouraged us to do hard work in our respective fields. I'm on the behalf of organizing team of Mahavir University. Thank you so much to all the participants for their significant presence. In this workshop, I am really thankful for giving me a chance to deliver a vote of thanks for our special guest speaker, who respected Dr. Nizam Ashraf Khan, Associate Professor and Head of IPR Cell, GD Goenka University, Gurugram, Haryana. He gave us to grace this workshop and also for enlightening us with his commendable talk over a topic of intellectual property right, proper attribution, copyright issues, and intellectual property rights, and also shared these valuable points such as about moral of the story, what is IPR, different types of IPRs such as patent, copyright, trademark, trade secret, design, others, and plagiarism. Thank you, sir, for your vital appearance and clearing our concept. I would like to thanks to Council for Teachers Professional Development India for collaboration with us. Now, I would like to thanks our convener Dr. Jugnu Khattar Bhatia, Secretary Finance at CTPD and Principal Satyug Darshan Institute of Education and Research Faridabad to be the part of our national workshop. Thank you, ma'am. I am running short of words to express my humble thanks to Professor Dr. Shivpal Singh sir, Dean Faculty of Education, Mahavir University, Meerut, for arranging this workshop. Sir, it's truly impossible without your motivation and support. Once again, thank you to our resource person, all participants and organizing team as well. Thank you so much to all. Thank you. Over to Ms. Danisha ma'am.
Thank you so much, ma'am, for valuable insights. Now, finally, I would like to invite Professor Dr. S.P. Singh, sir, for play the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
थैंक यू एवरीवन। बहुत ही अच्छा सेशन रहा सर, सब लोगों ने
धन्यवाद शिवपाल सर आपको।
थैंक यू
निरंतर इसी तरह कार्यक्रम आप करवाते रहें और हम लोग जुड़ते रहें। और मैंने सोचा था कुछ सर बहुत ही कम होगा, मगर आपने तो निरंतर इसे जारी रखा है और हमेशा मतलब कुछ समय के लिए तो अनछुए हो जाते हैं, मगर उसके बाद आप लगातार कार्यक्रम ये जुड़ना हमारे लिए बहुत बेशक अच्छा लगता है कि आपके जुड़ना और विद्वान वक्ताओं के साथ जुड़ना और निरंतर इसी तरह ज्ञान यज्ञ चलाते रहे, हम लोग जुड़ते रहे। धन्यवाद।
थैंक यू सर, थैंक यू वेरी मच। हमें भी बहुत अच्छा लगता है आप सबके बीच में जुड़ करके। उसी का नतीजा है कि ये हमारा तीसरा वर्कशॉप है, क्योंकि पहला हमने 10 डेज का सेमिनार रखा था, फिर 10 डेज का कॉन्फ्रेंस और अब आपका 10 डेज का वर्कशॉप के रूप में। और इसमें कोशिश ये है कि रिसर्च मैथोडोलॉजी से संबंधित जितने पॉइंट रेज हो सकते हैं हम सब पर उस पर बात करें। सो थैंक यू वेरी मच फॉर ज्वाइनिंग विद अस।
थैंक यू सो मच सर।
थैंक यू सो मच
सर मैं चाहूंगी कि आप बाइलिंगुअल रखा करिए, उसमें हिंदी का भी कंटेंट है, जिससे कुछ हमारे रिसर्च स्कॉलर्स होते हैं वो उनको परेशानी होती है, तो सर प्लीज इसका भी ध्यान रखें आप।
एब्सोल्युटली, मैं कोशिश करूंगा अपने अदर जितने रिसोर्स पर्सन होंगे उनको बोलने के लिए, लेकिन कभी कभी कुछ ऐसे टर्म्स और टर्मिनोलॉजी आ जाती हैं जिनकी वजह से उनका फ्लो उसी में चल जाता है।
जी जी सर, आप सही कह रहे हैं।
कई बार ऐसा नहीं हो पाता है, फिर भी हमारी तरफ से कोशिश होगी कि रिसोर्स पर्सन को पहले से इंस्ट्रक्ट कर दिया जाए कि नेक्स्ट टाइम से बाइलिंगुअल में रखा जाए। थैंक यू वेरी मच फॉर सजेशन।
थैंक यू सर।
और नेक्स्ट सेशन हमारा अब 4 तारीख को है, सो वी होप दैट वी विल बी बैक ऑन 4th of December.
Thank you, sir.
Thank you वेरी मच। हैव अ गुड।
सर कोई फीडबैक फॉर्म भी है सर क्या?
Sir, what about the today's attendance?
चैट बॉक्स देखा नहीं हमने शुरू से लेकर और अब तक 5 बार शेयर किया है।
जी
और
जी
मुझे लगता है आपको देखना चाहिए था। देखिए, आप अभी अभी देखिए चैट बॉक्स में मैंने लिंक शेयर कर रखा है।
सर एक बार और कर देंगे, मेरे पास नहीं आ पाया है अभी।
सर अभी शो नहीं कर पा रहा है।
शो नहीं हुआ है?
यस सर।
सर अभी शो नहीं हुआ है, एक बार और कर दीजिए प्लीज।
चलिए एक बार,
सर मेरा भी शो नहीं हो रहा है सर।
चलिए चलिए मैं अभी दोबारा से शो कर रहा हूँ, आप इसको देख लीजिएगा। और अगर और भी कोई दिक्कत होगी उसके बाद भी अगर नहीं आता तो मैं आपका जो
गॉट इट सर।
वर्कशॉप वाला जो हमारा ग्रुप है हम उसमें डाल देंगे।
हाँ सर, उसी में से डाल दीजिए सर, व्हाट्सएप ग्रुप में डाल दीजिए सर।
वो भी ठीक है, लेकिन मैं कई बार इसमें शेयर कर चुका था क्योंकि बहुत सारे पार्टिसिपेंट्स हमारे जुड़े हुए हैं, तो इस वजह से संभवतः वो दोबारा से नहीं देख।
मेरा नाम
इसमें संजय प्रजापति जी ने भी शेयर किया हुआ था, तो आप देखेंगे। मैं दोबारा से शेयर कर रहा हूँ, जरा चेक करें क्या इसमें आया।
यस सर।
तो आप इसको कर लीजिए, कोई दिक्कत नहीं, हम आपको 2-3 मिनट और देते हैं, आप इसको कर सकेंगे।
डिपार्टमेंट ऑफ एड्रेस।
ये हमने व्हाट्सएप ग्रुप में शेयर कर दिया है, तो आप लोग उसमें भी देख सकते हैं। थैंक यू वेरी मच।
थैंक यू सो मच।
थैंक यू।